Mr. Valle, I'm going to swear our interpreter in just in case you need her.
All right, there we go. I need to say something before everything starts. So,
Good morning, Liza Revere. Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to your best of your abilities, so help you God or upon penalty of perjury? I know. Thank you. That was a swearing-in interpreter.
I wanted to say something. Did you want to say something?
This is your attorney.
Right. Did you want to say something?
yeah, I try to talk to you because I never explained the situation why me run for the half an hour, you know, and I got an issue with the half an hour.
Hold on, Mr. Valle, before you continue, you are live streaming. This is being recorded. I haven't read you your rights yet, but I'm just you're speaking to your attorney. But I do want to just let you know that you're being recorded, and I have not read you your rights or anything like that.
Okay. So I can talk then?
Not right now. You wanted to talk about where you're going to be. Did you want to talk about where you're going to be placed when you're released?
Yeah, that too.
Okay. Well, there's a procedure. Do you want to go forward with this hearing today?
Yes.
Okay. So then we'll talk about where you're going to be placed later.
All right.
All right. Thank you.
Well, good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jorge Valle 323702. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
323702.
I'm sorry, can you just repeat your name one more time?
Valle, George Valle, 323702.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Attorney Robert Famiglietti of the Parole Revocation Unit of the Public Defender's Office.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Valle, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, you can lower your hand. Yes, thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. Oh, you can lower your hand.
I think he's raising his hand because he wants to say.
You want to say something?
I can talk now?
Sir. Okay.
Nah,
no, it's not your turn to talk, sir. So there's a procedure, a process that we go forward with in this hearing. And then at the end of the hearing, before she makes her findings, you can be heard. but now is not that
Oh.
time. We will let
Okay,
you know.
Thank you.
Thank you.
If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Now, do you have any questions about the purpose or procedure before we begin? Not about the charges, but about the procedure of this hearing. Do you have any questions?
No, I'm all right.
Okay. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So, Mr. Valle, I'm going to read the charges. You will have an opportunity to speak regarding the charges, but first I'm going to read all of them, okay?
Okay.
Charge 1, absconder. On June 4th, 2024, at approximately 1:25 p.m., you were observed on camera leaving the Maple Street halfway house without permission, and you failed to return to the Maple Street halfway house, which is your only parole-approved residence, and you failed to reside at this residence since that time. You failed to contact your assigned parole officer and halfway house staff, which means your current whereabouts are unknown. Charge 2, drugs. On February 20th, 2024, you signed a voluntary admission form admitting to using fentanyl. On March 28th, 2024, you signed a voluntary admission form admitting to you using cocaine on March 22nd, 2024. On April 3rd, 2024, you signed a voluntary admission form admitting to using fentanyl and cocaine on April 2nd, 2024. On May 28th, 2024, you signed a voluntary admission form admitting to cocaine and heroin on May 26th, 2024. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, signed parole conditions. Exhibit F, signed halfway house agreement. Exhibit G, voluntary admission. Exhibit H, signed misconduct. Exhibit I, voluntary admission. Exhibit J, voluntary admission. Exhibit K, signed misconduct. Exhibit L, app referral. Exhibit M, signed voluntary. Exhibit N, signed misconduct. And Exhibit O, Maple Street incident. Counsel, you received a notice of parole violation report, and the other documents that I just marked for identification purposes.
Yes, I am.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. It is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Yes, I've got no comment as to the preponderance standard as to the drug charges. However, regarding the absconder charge, my client's underlying crime was an intent or an attempt to take the life of someone else. It was not successful. The victim's family, known to the PO, known to the halfway house, someone was looking to kill him. The PO knew that. It's not in the report, but the parole officer was made aware of that. The halfway house was aware of that, and they were advising a move to move him to either Norwich or Hartford. My clients, there was word on the street. This was well-known, established fact. And for whatever reason, parole did not move him. He feared for his life. He kept telling the people at the halfway house and parole, they did not move him. The move was never made. My client was scared, and he left the halfway house for fear of his personal safety. He left out of necessity. He did not leave because he wanted to avoid his responsibilities, reporting to parole. He did not leave because he didn't wish to obey the rules. In fact, he abided by all the rules. The only misconducts are for 3 drug positives, and he completed an app referral and also went to evaluation at Connecticut Renaissance. So he did everything he was supposed to. He was there from January to June when he left, and he was remanded in November. No new crimes were committed. He was on the run to save his life. And so I don't believe the elements of absconder can be met. Thank you.
Thank you. Now, Mr. Valle, do you want to say anything in addition to what your attorney already put on record?
Nah, the only thing he said basically everything. So the only I said I'm apologize because I'm wrong, but I don't feel safe for my life, you know. So that's the only reason. But I want to continue on the street. I get married, and when I'm in the wrong, I get married. I got a family now. I got a wife, you know. So my priority now is being a halfway house on the programs to getting my job to take care of my people and my family, you know.
Thank you.
Thank you.
We can talk more about your plans in the future once the findings are made. I will speak. We filed an exhibit. I will speak to your past, present, and what you want to do in the future. And if you have anything to add, then you can, okay?
All right.
I'm just going to take a moment before I announce my findings. And before I do that, Mr. Valle, is there anything you wanted interpreted that you didn't understand thus far? Do you understand everything that's happening now, or would you like to use the interpreter?
Yes. Nah, I understand.
Thank you.
On charge 1, absconder, I make a finding based on state's exhibits B, E, and O, as well as testimony today. On charge 2, drugs, I make a finding based on state's exhibits B, E, and G through N. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, there's no doubt my client had a drug problem. If he hadn't left, and he left out of necessity, like we argued, this is an unusual, unique situation. This would have been a perfect top. He was referred as a result of those positive urines and successfully completed ACT. And he did that from April 2024, April 8th to May 8th. And then beginning on May 8th, he was at the Connecticut Renaissance Halfway House program, and he did an evaluation there. So my client is a married 39-year-old gentleman. He receives his support from his mother, 2 brothers, and his wife, Miss Rivera. He now has 3 stepchildren that he's very interested in also supporting. In the past, most recently, he was employed as a barber. He's worked also in the past at Park City Green, a mattress recycling facility in Bridgeport. He was there, but he had to leave ultimately because he has asthma, excuse me. As I stated, he completed the App Foundation. He was participating at the Renaissance in individual and group therapy. In the past, he's also completed an IOP, and he was on the waiting list for a domestic violence program, although that is not part of this violation whatsoever. He receives medical assisted treatment in the form of methadone. Upon release, he wishes to be sponsored by his wife, correct, sir?
Yes.
And that would be in Waterbury. And then as a backup plan, he's amenable to be placed in a halfway house in Waterbury. He's amenable to all job opportunities. And like I said, this is a unique set of circumstance. He's not a danger to himself. He's not a danger to the community. We wish that he be released as soon as possible because we don't believe the nature of this violation is so significantly serious to warrant further incarceration. He's been held since just before Thanksgiving. We don't believe further confinement is necessary or appropriate. All of his prior issues have been as a result of drug use. Thank you.
Thank you. Mr. Rajay, is there anything you'd like to add that your attorney did not put on record?
He said basically everything.
Okay, thank you. Now I'm going to take a moment before I announce my recommendation. Okay, Mr. Valle, being that this is your second violation, your first violation occurred about 4 months after being released on special parole supervision, at which time you received a criminal conviction. Then from there, you were released, you received a sanction, you were released. Upon your release, you were supervised in the community for approximately 5 months prior to absconding from parole supervision. And then your whereabouts were unknown for approximately another 5 months. Taking that into account, and prior to absconding, you also received 3 misconducts for ongoing use. I'm also taking into account that you did participate in and complete treatment. But being that this is your second violation, you absconded this violation, your whereabouts were unknown for 5 months. I recommend revoke and reparole on June 25th, 2025, which is an approximate 7-month sanction with the following conditions. Anger management, no contact with co-defendants Jonathan Marciliano, Ralph Green, no contact with victims CN and ED, halfway house placement in the event that it is needed, and a mental health evaluation. My findings and recommendations will be forwarded to the board, and you will receive official written decision from the board, and your board review is scheduled on February 6, 2025. Now, on that date, the board is going to take a look at your case. They can lessen my recommended sanction, they can keep my recommended sanction, or they can exceed my recommendation, being that you're on supervision until October 2033. And if they do exceed my recommendation, another hearing will take place, and they will outlining the reasons why they want to exceed my recommendation. Okay?
You understand that, sir? Her recommended release date is June 25th. It's up to the board now. They'll meet on February 6th and make their final decision. Okay, sir?
All right.
Okay, thank you. This concludes your revocation.
Call me if you have any questions, sir, okay? Call me,
All right.
okay? Thank you.
Just give me a second so that you know who's not here.
Good morning.
Hi, good morning.
So we should have a few with you this morning, Mr. Yakubu,
Yep,
McElroy, and Perry.
correct.
If we could get started with Yakubu, that would be great. Is he there?
Okay. Yes, I have them all.
Awesome. So we'll just go down the list.
Okay, so Yakubu, then Perry, and then McElroy.
That's fine.
Okay. Okay.
Thank you.
Thank you. Yep. Yakubu.
Good morning, Mr. Yakubu.
Good morning.
Am I saying your last name correctly, Yakubu?
Yes.
Okay, we're gonna get started in about 5 minutes. I'm getting your attorney as well as your PO on the line.
Thank you.
Thank you. Good morning, PO DeVylder.
Good morning.
We'll get started in just a few minutes. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Muhammed Yakubu 366-932. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Muhammed Yakubu, inmate number 366-932.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Yakubu.
As well as your parole officer.
Parole Officer DeVylder, Hartford Special Management Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact on each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Yakubu and P.O. DeVylder, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officers bring against you, and the information underlying each charge. Charge 1, obedience to the law. P.O. DeVylder.
According to Hartford arrest warrant CFS 2400235595, at approximately 5:17 p.m. on 6/18/2024, you were involved in a motor vehicle accident and fled the scene. Connecticut State Police were dispatched to the scene of the collision, where there was damage to the complainant's vehicle's rear bumper and tow hitch. The operator of the damaged vehicle was able to provide the license plate of the evading vehicle, which was registered to your girlfriend. When CSP made contact with her, she identified you as the individual that was operating the vehicle at the time. On 6/19/2024, the investigating trooper made contact with you via telephone. You admitted that you did strike the vehicle and fled the scene. A request for an arrest warrant was drafted and probable cause was established when it was signed by a judge on 9/4/2024. On 10/2/2024, Connecticut State Police served you with the warrant and charged you with evading responsibility, 14-2024 B3, and following too closely, 14-240B. Subsequently, you were transported to Hartford Correctional and a remand to custody was lodged by parole staff.
The state has filed the following exhibits, starting with Exhibit A.
Parole conditions. B, parole violation notice. C, parole violation report. D, remand to custody. E, State of Connecticut Judicial Branch pending case detail, and F, Connecticut State Police arrest warrant 2400235595.
The state has filed an addendum to Exhibit C, which states on December 23rd, 2024, Mr. Yakubu's charges of evading responsibility and following too closely were substituted to failure to stop. As a result, Mr. Yakubu received a $100 fine. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
I did. There were 2 addendums that were filed. Can you put the first one on the record also, please?
The first addendum states on December 23rd, 2024, Mr. Yakubu case for evading and following too closely was disposed of, and he was ordered to pay a $100 fine.
Thank you.
And did you receive the document?
I did.
And the defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. DeVylder?
Yes, I would just like to make a quick note for the record. Regardless of the court's outcome, we are here because of the criminal behavior of Mr. Yakubu. He was operating a motor vehicle, which he admittedly hit and damaged another vehicle. Yet he left the scene because, and I quote, "I had to poop real bad." Any law-abiding citizen knowingly involved in an accident would have relieved themselves and made an effort to go to the police station or at least make a telephone call to take responsibility for their behavior. Instead, Yakubu went home and went to bed. He did not try to resolve the situation, nor did he even report it to me until weeks later after I received notification from the police. Because of his negligence, the police had to execute a criminal warrant for his arrest, which led to this remand. The outcome of the court is irrelevant as Yakubu intentionally left the scene of a crime and did not handle his responsibility appropriately. Thank you.
Thank you. It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes. Regarding the parole officer's comments regarding the conduct she charged my client with on the parole violation before was not the same conduct that he was presented with in criminal court. I'm going to provide you with some information which is dated December 23rd of 2024. My client was not presented an evading responsibility for following too closely. I understand the parole officer's comments regarding what occurred. And she referred to it as the outcome from court. But what she charged him with was not even presented in court. And I have some questions for the parole officer. I can't pronounce, I always butcher her last names. I'm about parole officer. P.O., do you recall a phone call I made to you on January 10th of 2025 regarding Mr. Yakubu?
I do, and I was instructed that it needed to go before the board and that I am not to talk to you.
Okay. Do you recall me questioning you regarding the first addendum that was put on a record regarding case for evading responsibility and following too closely was disposed of and was ordered to pay a $100 fine? Do you recall me telling you that that information was not correct?
It wasn't that it was not correct. It was just the wording of my addendum.
Okay. And I asked you, do you recall me asking you if you had the substituted information from court?
Sir, this is irrelevant. He was arrested on a
It's not
warrant for
relevant.
evading
She needs to
responsibility.
answer my questions on the record. She's under oath and I have a right to defend my client. She has to answer. She can't take the fifth. That's not the way this process works.
Could you repeat your question?
Yes, my question is, was she aware of the substituted information that was presented in court?
What substituted information that was presented in court, sir?
The information that I emailed you, which you didn't have, and I have a copy of the email I sent to you.
And the addendum is correct?
Did I email you some documents that provided you with the substituted information from court from December 23rd of 2024?
Yes,
Okay.
but the substituted information has no relevance to why we're here today.
In your opinion, I'm entitled to my opinion. Now, you're under oath. I have some questions and you need to answer the questions. That's your job.
Continue.
So the follow-up question is, do you recall you telling me after I sent you those information that you're going to check with your supervisor and you were going to call me back and you asked me for my cell phone number? Do you recall that conversation?
I do. And then when I went to my supervisor, I was instructed that at no way, shape, or form are you supposed to be contacting me directly, and that it's going to go to the board before a revocation hearing, and I am not supposed to speak to you.
Okay, that's fine. That's PCS position. That's fine. I provided you with the information you didn't have. Then on January 13th, you filed a second addendum, which you sent to PO Muniz. Is that correct?
I did.
Okay. And that second addendum had information which I emailed to you, which I provided to you, which you didn't have on January 10th. Is that correct or not?
Yes.
Okay, thank you. I'm asking that a no finding be made. The charged conduct was not presented in court. The original addendum, as P.O. DeVylder indicated, the wording was not correct. It wasn't just the wording. The substituted information is very relevant because it's not where an initial charge was nollied or was dismissed. That conduct was not presented in court. Did I hand that over to you? I'm sorry, I started to. This is the court documents that I was able to obtain through my investigator. That is the charge that he was presented with in court, which is an infraction. There are no charges
May I
that were not.
interrupt?
You're going to definitely have a field of all you'll have another opportunity to speak. Absolutely. But
Thank
I'm
you,
going
P.O.
to have
Sanders.
pro officer, or I'm going to have Attorney Sirica finish his thought.
Thank you. That's the charge that was presented in court. It wasn't a situation where charges were nollied or dismissed. That was a singular charge that my client was presented with in court on December 23rd of 2024. That is a copy of the clerk's information sheet, which I emailed to the parole officer with a couple other documents, which lists what happened, who the judge was, who the prosecutor was. So prosecutor's discretion file the substituted information. That's who files that, the state's attorney's office, not the defense attorney, obviously not my client. That's what he was presented on in court, which is an infraction.
Okay. So I'm going to mark this as exhibit number 2 from the defense. Okay. Anything further before?
Not at this point.
Okay. P.O. DeVylder?
I would just like to reiterate, he was remanded on a warrant for those charges. What Sirica is referring to is a further court date of December 23rd, which Yakubu had been in court multiple times before that. He had been arraigned on the charges of evading responsibility. Regardless if the attorney subbed it down to an infraction is not the point. The point is he had a warrant for criminal behaviors for the evading responsibility.
Anything further?
No.
Thank you. Counsel? Anything? Okay. I'm going to take a recess before I announce my findings. So it's going to just be a moment. I'm going to step out.
Hello, good morning, welcome everybody. How is everybody doing today?
We are now back on record. Taking into account both the state as well as the defense arguments today, on charge 1, obedience to the law, I make a no finding on the following charge. Following too closely, as this charge is an infraction, which is neither a crime nor an offense. I make a finding on a parole violation for the rest of this charge based on state's exhibits A, C, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history.
I apologize, but I need for you to repeat that one more time, what you just put on the record.
So the charge, based off of the PBR, he was charged with following too closely and evading responsibility. I make a no finding on following too closely as that's an infraction, because that's not considered a crime nor an offense. But I do make a finding on evading responsibility.
Thank you for clarifying that.
Pierre DeVylder, do you wish to make a statement regarding Mr. Yakubu's background and history at this time?
No, thank you.
Counsel, do you wish to make a statement?
Regarding his background history, yes, I do. I am asking for my client to be reinstated as soon as possible, based on those findings. If my math is correct, my client was paroled, looks like on July 28th of 2021. It's not remanded till October 2nd of 2024. My client, he's 38 years old, is out in the community for 3+ years. Once again, if my math is correct. He was placed at the the REACH program. He was there until he was remanded on October 2nd of 2024. He did have a full-time job prior to his remand. He had good work history, but his last job for the past 2 years was full-time employment for Dun Paper, which is now called By Origin Specialty Products out of East Hartford. He had good job with good benefits. He reported to us. He did briefly work with individual therapists at CRT in Hartford until he got a job. And while he's been, since he's been incarcerated at Robinson, he's working as a chairman, doing cleaning bathrooms and showers, etc. He would like to return to the department through the REACH program in East Hartford. He said that was the best thing that happened to him. He liked where he was and said he was out for 3+ years. And at some point, he'd like to enroll in Tractor Training School to obtain his CDLA license. And he's indicated to us he can return back to his full-time job at the paper place. Thank you.
Thank you. I'm just going to take a moment before I make my recommendation.
P.O. Saunders, can I just make a quick statement?
Oh, yes, absolutely.
So the REACH program is usually only available for a 6-month duration. Yakubu was there for approximately 3 years. So at this time, that apartment is no longer available to him. So I would just recommend a halfway house stipulation be added to his conditions for a halfway house placement. I think he wants the Hartford area, if I'm not mistaken.
Is that correct, Mr.
Could you
Yakubu?
just clarify that? She beat me to it. I was going to ask Mr. Yakubu, what part of the state do you want to go? Hartford, your parole officer knows you a lot better than I do. Is that where you want to go?
Yes, I want to go to Hartford because it's closer to the job.
Okay, perfect. Thank you.
Anything further, P.O. DeVylder?
No, that's all.
Thank you. And Councilor
I don't have anything else to add.
Mr. Yakubu, is there something you wanted to say?
Yes, is there any way I can get DeVylder as my PO back again? Because she was a good PO, and I'd like to continue with her.
I don't think, if I misspeak, please God. We don't control that part of it, Mr. Yakubu. Once you get re-paroled, that's up to the field office. I don't have any control over that. Neither does the hearing examiner. That's great. You had a good working relationship with her, but we don't control that here.
Okay.
Thank you. I recommend revoke and re-parole on February 6, 2025, which is an approximate 4-month sanction, with the following conditions: no consumption of alcohol, no contact with co-defendants James Tyson, Earl Gelman, and Sherelle King, no contact with victim LM, a general no contact with SMC, halfway house placement, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board. you will receive the official written decision from the board, and your board review is scheduled on February 6, 2025. On that day, the board's going to take a look at your case. My recommendation is for you to be released on February 6th. So they can agree with that recommendation, and being that you're on special parole, if they agree, you would be released on February 6th. If they don't agree, they can exceed my recommendation, being that you are on supervision until May 2032. And if they do want to exceed my recommendation, then another hearing would be held so they can explain why they want to exceed my recommendation of a 4-month sanction. Okay, any questions?
No.
So Mr. Yakubu, you will know if the board adopts the recommendation if you get released on the 6th, because it goes to the board at 9 o'clock in the morning. If they adopt the recommendation, you get released that afternoon. Okay?
All right.
All right, good luck to you.
Thank you. This does
Thank you.
conclude your revocation hearing. Thank you.
Thank you.
Thank you.
Thank you.
All right, thank you, Mr. Valle.
And I should see you back around 11:15 p.m.
Yes, definitely.
Thank you.
Thanks.
Good morning, sir. What is your name?
Brian Perry.
Okay, give me a moment. I'm going to connect with your PO and you don't have an attorney. So I'm going to connect with your parole officer, okay? Thank you.
Yes, ma'am. All right.
For her. Good morning, PO Gerard. I believe you have to press either *4 or *3 to unmute if you're trying to unmute. There it is. Can you hear me?
Hi, this is P.O. Gerard.
And I have Mr. Perry here. We're going to get started.
All right, perfect.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Brian Perry, 373-781. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Perry, 373781.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your parole officer.
Hi, Parole Officer Gerard.
This is a preliminary hearing which has 3 purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if that act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Perry and P.O. Gerard, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or on penalty of perjury?
I do.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state Bureau parole officers bring against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney if you cannot afford an attorney. And if you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state Bureau parole officers bring against you and the information underlying each charge. P.O. Gerard, starting with charge 1, GPS.
All right. Charge number 1, GPS. On January 6th of 25, you signed out of Stein Halfway House at 4:25 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A in West Hartford, Connecticut, at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. Therefore, you are unaccountable in the community for 7 hours, 20 minutes. This is in violation of your GPS monitoring agreement that states, I will follow all established curfew, work, and program schedules, and must obtain prior permission from a parole officer prior to changing any established schedules. On January 7th, 25, you signed out of Stein Halfway House at 3:57 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A in West Hartford, Connecticut, at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. Therefore, you are unaccountable in the community for 7 hours, 48 minutes. This is in violation of your GPS monitoring agreement that states, I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. On January 9th of 25, you walked out of the Stein Halfway House without authorization. You walked out the door at 1:01 p.m. and did not return to the Stein Halfway House until 3:28 p.m. Therefore, you are unaccountable in the community for 2 hours, 27 minutes. This is in violation of your GPS monitoring agreement that states, I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. Charge number 2 is halfway house placement. On December 11th of 24 at 9:57 p.m., you exited the front door of Watkinson Halfway House. A staff member followed you to inquire where you were going, and you responded, y'all called the effing cops, right? And continued out the gate and off the property. Your assigned parole officer made contact with you and instructed you to return back to Watkinson Halfway House. You returned to Watkinson Halfway House on 12/12/24 at 3 p.m. Your whereabouts in the community were unknown for 17 hours and 3 minutes. This is in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On January 9th at 1:01 p.m., you walked out of Stein Halfway House without authorization. Halfway house staff instructed you that you were not authorized to leave. Your assigned parole officer made contact with you and instructed you to return to Stein Halfway House. You returned to Stein Halfway House on January 9th of 25 at 3:28 p.m. Therefore, you are unaccountable in the community for 2 hours, 27 minutes. This is in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole.
The state has filed the following exhibits, starting with Exhibit A.
Exhibit A, notice of parole violation number 1, which was signed on January 15th of 25. Exhibit B, notice of parolee rights number 1, signed on January 15th of 25. Exhibit C, remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, case notes interaction from October 15th of 24. Exhibit G, case notes interaction from November 11th of 24. Exhibit H, case notes interaction from November 13th of 24. Exhibit I, community solutions incident report. Exhibit J, community solutions incident report. Exhibit K, offender misconducts. Exhibit L, offender misconducts. Exhibit M, GPS monitoring agreement. Exhibit N, Stein halfway house incident report. Exhibit O, offender misconducts. Exhibit P, Allied Universal GPS monitoring report. Exhibit Q, offender misconducts. Exhibit R, Allied Universal GPS monitoring report. Exhibit S, offender misconducts. Exhibit T, Allied Universal GPS monitoring report. Exhibit U, Stein halfway house discipline report. Exhibit V, Stein halfway house incident report. Exhibit W, Stein halfway house discipline report. Exhibit X, Stein halfway house incident report. Exhibit Y, notice of parole violation number 2, which was signed on January 17th of 25. Exhibit Z, notice of parolee rights number 2, which was signed on January 17th of 25. And Exhibit AA, the parole violation report.
Mr. Perry, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, ma'am.
And did you have time to review it?
Yes, ma'am.
Today we have no witnesses. And Mr. Perry, it is now your opportunity to respond. Oh, I'm sorry, I'm going to start with P.O. Gerard. P.O. Gerard, at this time, it is now the state's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Yes, as far as charge number 1 with the GPS, Mr. Perry was had the Allied Universal GPS monitoring device on his ankle, which showed that on the 3 days, January 6th, January 7th, and January 9th, that he was not where he was authorized to be on those dates, and we have the monitoring reports that back that up. And as far as charge number 2 in the halfway house placement, he was at 2 different halfway houses over a 30-day period where he left the halfway house without authorization and was unaccountable in the community.
Thank you. Anything further?
Well, I guess what I would say is that there are case notes, the interactions that are part of the evidence that just show that I think Mr. Perry was having a very difficult time with parole and when with, the conditions of parole and, some of the parameters that were set on him. And I think in some of these cases, his anger had, gotten the best of him and, were a detriment to him, being successful on parole, despite, parole trying their best to get him to have a successful time on parole.
Thank you. Mr. Perry, it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, ma'am.
Go ahead.
I agree with Gerard about the anger. A lot of things I didn't really understand. That was like my first time really in a halfway house. So I'm used to dealing with a special parole officer on a one-on-one basis instead of having to wait for certain things. So it's like I didn't understand when they told me about certain restrictions. I didn't understand because when I was in one halfway house, they was allowing me to do certain things. Then when I get to this halfway house, I was supposed to go home, which I felt like when it came to my programs, like CRT, certain things, I don't know if it was I don't know if they got notice of it or whatever. So it was like, I felt like a lot of things was taken from me without explanation. And instead of me really just waiting and sit it out, I allowed my anger to just really get the best of me. You know, I wasn't used to that setting. And I did certain things I did what I felt was best. Like when I walked out, when I was at the Watkinson house, I walked out because I tried to de-escalate the situation the best way I know how, and that was to walk away instead of engaging. And I went to CRT because I knew that it was a program. I had to give a urine, and I just really was kind of confused when she told me that I was under restrictions. It wasn't like really broken down to me how far my restrictions went.
Anything else?
Oh man.
Okay. And P.O. Gerard?
Yes, nothing else.
Okay. On charge 1, GPS, I make a no finding of probable cause on part 3, as the state failed to provide sufficient evidence to prove Mr. Perry's action meets the elements of this charge. I make a finding on the rest of the parts listed in this charge based on state's exhibits D, M, O, P, Q, R, U, and AA. On charge 2, halfway house placement, I make a finding of probable cause based on state's exhibits D, E, I, J, L, S, W, and AA, as well as testimony today. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. So, Mr. Perry, your revocation hearing will be scheduled within the 60 business days since you've come back into custody. You will receive a hearing disposition, which will have a tentative hearing date listed, but please keep in mind that all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violate the conditions of your parole, and if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanction should be imposed. Okay, so that does conclude your preliminary hearing, and again, you'll receive your hearing disposition with your revocation date, which is again tentative. Okay.
Yes, ma'am.
Any questions?
No, ma'am.
You're all set. Thank you, Mr. Perry.
All right, thank you. Yeah, have a good day.
Thank you, Mr. Perry.
Gerard.
Thank you.
Good morning.
How you doing, Miss?
Good. How do you pronounce your last name?
McElroy.
McElroy. Okay, give me 1 second. I'm going to get your attorney as well as your PO on the phone.
Okay.
Thank you. Good morning, P.O. Barrios.
Yes.
P.O. Barrios, it would be, I believe, a *4 to unmute.
Hi, this is Officer Barrios. Hi, this is Officer Barrios.
Good morning. We're going to get started right now.
Okay, perfect.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Chaz McElroy, 345-907. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Chaz McElroy, 345-907.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Hannah Dean for the record on behalf of Mr. Elroy.
As well as your parole officer.
Parole Officer Barrios.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact at each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. McElroy and P.O. Barrios, please raise your right hand. Do solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney, as well as the state, will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Barrios, please start with charge number 2, notification of arrest.
Okay, give me a minute. Notification of arrest. Okay. On April 12, 2023, a valid non-extraditable warrant for failure to appear, FTA, was issued by the court. You have 48 hours to notify your parole officer of any arrest or offense. You were arrested and charged, and you did not contact your parole officer. You were charged with the following charges: DUI, controlled substance, impaired ability, first offense, trespass by motor vehicle, disregard traffic lane, careless driving. You did not notify your parole officer of the arrest. Based on your behavior, you are in violation of your special parole conditions. Obey all laws. Notification of arrest.
Charge 3, travel.
On April 5th, 2023, you failed to appear for a scheduled preliminary hearing at the Commonwealth of Pennsylvania Court of Common Pleas, 49 Judicial District. You were involved in a motor vehicle accident in Central County, Pennsylvania, and subsequently arrested and charged. You traveled to Pennsylvania in 2023, and you did not request a travel pass. You did not have permission from your parole officer to leave the state of Connecticut. You left the state of Connecticut without prior written permission from your parole officer Based on your behavior, you are in violation of your special parole condition, travel.
Charge 4, no consumption of alcoholic beverages.
Prior to 4/5/23, you were involved in a motor vehicle accident in Central County, Pennsylvania. You were arrested and charged with DUI, controlling substance, impaired ability, first offense, trespass by motor vehicle, disregard traffic lane, careless driving, docket CP 14 CR 00004562023. Throughout your period on parole, you are prohibited from the consumption of alcohol. Based on your behavior, you are in violation of your special parole conditions, additional conditions, consumption of alcohol beverages. Do you want me to, I'm going to do the other one also, right? Charge 4?
Yep. Yep.
On 4/17/2024, you were alleged to be driving a motor vehicle under the influence of alcohol, resulting in a motor vehicle accident. Farmington PD responded to the area of Farmington Avenue for an OnStar alert of a motor vehicle accident. Upon arrival, officers made contact with you as the operating of a blue Chevy Malibu plate MA5XKE69, as you were confused about your direction of travel and having a strong odor of alcohol emanating from your breath. You were asked to perform a standardized field sobriety test. You failed to perform all the SFST to standards and administered a breath test of 0.1560. Throughout your period of parole, you are prohibited from the consumption of alcohol. You were arrested and charged with operating under the influence, 14227A. Based on your behavior, you are in violation of special parole, additional condition, consumptions of alcohol.
The state has filed the following exhibits, starting with Exhibit A.
Conditions of parole. Do you want me to do the exhibits?
Yeah, all exhibits, please.
Okay. Exhibit A, conditions of parole. Exhibit B, remand to custody. Exhibit Z, parole violation report. Exhibit D, notice of parole violation. Exhibit E, Farmington Police Report 24000061119. Exhibit F, letter from Sheriff Brian Samsell, Central County Sheriff Office. Exhibit G, Commonwealth of Pennsylvania, 49th Judicial District, bench warrant failure to appear, page 1. A final revocation in your case has been scheduled for.
Thank you. The state filed an addendum to Exhibit D, which states PCS has requested the withdrawal of the re-imprisonment warrant for Charge 1, obedience to the law, and to only consider Charges 2, notification of arrest, Charge 3, travel, and Charge 4, no consumption of alcoholic beverages. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, we have.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the state's opportunity to present evidence and speak to any of the evidence submitted. P.O. Barrios?
Yes. I'm sorry, what was your question?
Would you like to make a statement regarding the parole charges?
Yes. I would like to just emphasize that Mr. McElroy was very aware of his additional conditions and of his conditions, and he continued to violate, knowing that he already had this Pennsylvania issue. He continued to, use alcohol and drive a vehicle under the influence. He at no point at any time intended to share that information in Pennsylvania or even try to resolve the problem in Pennsylvania, knowing that he had a promise to appear. And he at no time notified me of his travel.
Thank you. Anything further?
Not at this moment.
Okay. And it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yeah, just some global comments as to the different charges. So the most recent addendum that was referenced, addendum 4, is accurate. For both of the cases that were referenced in the PVR, my client did receive diversionary programs where, if successful, those will result in dismissals of everything. So no convictions at this time. He's looking forward to getting started with the treatment components of those programs ASAP. He's optimistic about earning dismissals in both those matters. I also want to note, just for the second round of exhibits that were submitted on 1/14/25, I just want to note that his signature is missing on a few of those. I just thought that that was worth indicating for the record. But here we're just left with technical violations. So those are my comments as to the charges. And at the appropriate time, I would like to speak to his background and future plans.
Okay, thank you. And
Can I add? Yes. Can I add something to what she made her statement on?
Yes.
Okay, so yes, he's been given these programs and he is on probation with Pennsylvania as we speak. And he has to pay some restitution, which they don't see. They're seeing an issue with it, being that he's incarcerated. He's gonna eventually end up in violation with this because he won't be able to take care of his probation in Pennsylvania while being incarcerated or being out. And the missing signatures is because he has to be issued this paperwork for his signature and sent to Pennsylvania that I don't know why he hasn't received and signed. But I have a copy of it that I can submit to him so he can sign and submit to Pennsylvania. But yeah, I spoke with Pennsylvania probation officer, and this is something that he needs to be in compliance with. And he stated that it may be kind of complicated, difficult for him to stay in compliance, being that he is incarcerated and has to pay this restitution and has to report to probation in Pennsylvania and do some other conditions in regards to his probation in Pennsylvania. So this was not something that, like the attorney said, that it was discharged.
Okay, thank you.
If I may just respond, I never made any representations that this was discharged, but this is my understanding. The program he was entered into in Pennsylvania is very similar to the programs that were available here in Connecticut, where the person's monitored by probation, but they aren't necessarily on probation as no conviction has been entered there. So I will just note that if he's successful, my understanding is that that case would go away, much like the result of this in Connecticut. I also just want to make clear that at this point, he hasn't been given an opportunity yet because he is incarcerated to start doing some of that stuff for the program. I don't think it's fair to state at this point that he's going to be unsuccessful in any of that, as he hasn't had an opportunity yet to work on the program while out and make those restitution payments. So I will just, argue that this is he was given the program for this situation for a reason. Clearly, he has a number of things to do in the community once he gets out. However, that isn't one of the charges here. That has been removed, that obedience to the law charge. I just wanted to note that for the record. Thank you.
Thank you. And P.O. Barrios, anything further?
No, not at this moment regarding those charges.
Okay, thank you. And you're also okay.
Yes, thank you.
I'm just going to take a moment before I announce my recommendation or make my findings.
Okay.
On charge 2, notification of arrest, I make a no finding as the state failed to provide sufficient evidence to prove Mr. McElroy's action meet the elements of this charge. On charge 3, I make a finding for charge 3 travel, I make a finding based on state's exhibits A, C, F, G, and H. On charge 4, no consumption of alcoholic beverages, I make a no finding on part 1 as the state failed to provide sufficient evidence to prove Mr. McElroy's action meet the elements of this charge. I do make a finding on the rest of the parts listed in this charge based on state's exhibits A, C, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. P.O. Barrios, would you like to make a statement regarding Mr. McElroy's background and history at this time?
For when I supervised him?
Yeah, programs of participation, his background or his future plans. Is there a statement you
So
want to
I
make?
see, so I see some of the parole accomplishments that the attorney listed for exhibits, the list of exhibits. And she stated some employment with, I had a very difficult time with Mr. McElroy trying to get confirmation of his employment. He would not submit pay stubs as requested on a weekly and monthly basis. So there was never me able to prove that he was working at those locations for those time periods. Mr. McElroy also was transferred from me from the mental health unit and was not, had a lot of difficulty with his residence. His mom went back and forth with me a couple of times requesting for him to be removed from the residence because she wasn't able to continue to be responsible for his supervision while on parole. So I just want to put that on the records, please.
Okay, thank you.
Yes, thank you very much. So my client is 37 years old, born and raised in Hartford, Connecticut. Primary source of support is his mother. He also has one son who resides in state here with his mom. Most recently, while on special parole, he was sponsored by his mom, Kim Robinson, in New Britain. Way back in September 2011 to March 2012, he reportedly studied business administration at Sanford Brown Institute College in Farmington, Connecticut. From 2023 to 24, he reports that he attended a barbering program at the Academy di Capelli in East Hartford and had completed 6 months out of that 9-month program. He reportedly utilized various tip agencies for placement, including Staffing Solutions, Accurate Personnel. He also reports employment at NRL located in East Windsor. That was through a tip agency as well. He reports being there for approximately 6 months. Prior to being remanded, he also reports he was at Home Depot in Holyoke, Mass. And that was up until the week prior to remand. I think that was a previous job before while on supervision. In March 2019, when he was on supervision, he did do an intake at Rushford and Middletown and reports that there wasn't any treatment recommendation from there. And then in July of that same year, he did an intake at CRT. He previously was at the Eddy Center and reports while there, he had volunteered at a food pantry in Middletown for about a month and a half until he got an actual job. He was on a minimum contract schedule and was employed in the kitchen upon remand, so he's been working while incarcerated. From reviewing his prior DIF summary, it appears that there haven't been any disciplinary reports since way back in 2011, so he is doing very well, not picking up any tickets. Upon reinstatement of his special parole, he's open to being placed at a halfway house in Hartford. He would prefer open hearth or Watkinson House if beds are available at either of those. He's also hoping to return to that barbering program at the Academy di Capelli. He's got about 3 months left until he's completing that. And then he's hoping, and as well in the meantime, to utilize a temp agency. He also eventually wants to go back to school, do a tractor training certificate to obtain a CDL. And he's open to any sort of treatment recommendations. And then also he'll be doing the treatment that's required for these diversionary programs. I know as far as Connecticut goes, that typically includes anywhere from 12 or more substance use or alcohol classes. So I think that he will be in treatment by virtue of that. He also has every incentive to get back to work in order to make those restitution payments. So he's going to be very busy once he's back in the community, but I believe that he will do well since he will have, some additional supervision by way of those programs. He's been incarcerated on this matter since April of 2024, so he's effectively served over 9 months already on this violation. This is the first violation, I believe, on this period of supervision. It sounds like he's been out since 2022, and I believe that the penalty he's already served is more than enough. So I would ask that he be provided the soonest possible re-parole date. Thank you very much.
Thank you. P.O. Burials, anything further?
Well, I understand that she feels that he will have a good opportunity to be back in the community, but I don't see this being possible for Mr. McElroy, being that he has our supervision, our programs, and then also Pennsylvania also to be done. And I think he needs to be done an intense mental health evaluation to see if he's gonna be, supervised by district or mental health unit.
Anything further?
No.
Thank you. Council, anything further?
No, thank you.
Thank you. I'm just gonna take a moment before I make my recommendation.
Mm-hmm.
I have that Mr. McElroy has been on supervision since November 2019. Is that correct, Mr. McElroy? You've been on supervision
Yes.
since 2019 for special parole. You were discharged? Special
Yes.
parole? Okay. And this is not your first violation, correct? This is what I have per our records. This is not your first violation.
Mm-hmm.
And taking all this into account, in these current charges, I recommend revoke and reparole on February 6, 2025, which is an approximate 9.5-month sanction with the following conditions: no consumption of alcohol, halfway house placement, and a mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on February 6, 2025. So on that day, the board's going to take a look at your case. They can agree with my recommendation, which is releasing you that day, which is February 6th, and being that you're on special parole, that would be your release date, February 6th. If the board does not agree, they can impose a sanction longer than what I have recommended, being that you're on special parole until February 2026. If they do recommend a longer sanction than what I've recommended, then another hearing would take place, outlining the specific reasons why they might want to exceed this my recommendation of February 6, 2025. So if you're released on that day, then you know the board agreed. If you're not released on February 6th, that means there's going to be another hearing.
Okay.
All right. And any questions, Mr. McElroy, give me a call at my office, okay?
All right.
All right,
Thank you.
Thank you. You're all set. Thank you, P.O. Barrios.
Okay, that was, February 6th or 26th?
February 6th, 2/6/25.
Okay, thank you.
Thank you.
Thank you so much.
Good morning.
Good morning. He'll be down shortly.
Okay, thank you.
This is for McEntyre, correct?
Correct. Yep, thank you.
He's coming down right now. No problem. Yeah, that's the one that's. McEntyre. Yep. McEntyre.
Okay.
And this floor gauge is the ground that you have video. You're already logged in. Right there. B.
Good morning, Mr. McEntyre.
Good morning. How you doing? Happy New Year.
Yeah, thank you. We're gonna get started once your attorney's available. He's in another hearing. As soon as he's done, we'll get started.
Okay.
Thank you. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Mark McEntyre, 100822. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center. Please state your full name and VOC inmate number for the record.
Mark McEntyre, 100822.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, behalf of Mr. McEntyre this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. McEntyre, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, go ahead.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, absconder. On May 25th, 2024, you left your only approved parole and community service residence, the Sierra Center Halfway House, and never returned. You had no further contact with Sierra Center Halfway House staff or this officer. You left your only parole approved address without program completion and became unaccountable in the community. Subsequently, your whereabouts in the community are unknown. Charge 2, halfway house placement. On May 25th, 2024, you signed out from your approved residence at the Sierra Center Halfway House on an approved community pass for work at 10:19 a.m. with an 11:40 p.m. return time. You failed to contact your parole officer or halfway house staff, and you failed to return to the program by the return time. Your actions violated your signed halfway house agreement. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, signed parole conditions. Exhibit F, signed halfway house agreement. And Exhibit G, Sierra halfway house incident report. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, regarding charge number 1. Mr. McEntyre, under the absconder charge, it says that May 25th of 2024, you left your approved parole community service residence. Where did you go?
I went to my house, 39 Edward Street, because my mother had dementia. And my brother, who was staying there, we got cameras all over the house. Every time that we look on the camera, he was gone. And, I know I was wrong for, not returning, but I sacrificed my freedom for her safety because, And that's the only reason why I didn't come back. I was still working. I was doing.
I'm going to get to that, though. Look, I went to your mother's house. How old is your mother?
80 years old.
80. And what town is your mother's house in?
Hamden.
Hamden. Okay. And during this period of time, you were not reporting to your parole officer from May 25th of 2024 on. Were you still working at KFC?
Until July, yes.
Okay. So from May 25th till July, you were working at KFC. What town was KFC in?
Is there, Orange?
Okay. Did anyone from Parole?
No one came by the job or came by the house. And I was like, nobody came by. Yeah, no one showed up.
All right. During May 25th until you were remanded in November, did you ever leave the state of Connecticut?
No.
Okay. So you were at your mother's address and you were still working at KFC during that period of time, right?
Yes.
All right. And were you doing anything else besides working and trying to take care of your mother?
I was going to Olive Street, they got meetings. And at 12 o'clock. And
okay, how often were the meetings?
Every day.
Every day.
12 to 1.
Okay. All right. I don't have any other comments regarding that charges. It's through my client's testimony after speaking to him on telephone. He self-admits he was at his mother's house for the period of time. He was still working at Kentucky Fried Chicken. And he was still going to a meeting from 12 to 1. I know they called the local hospitals and they called the local police stations. Right from my client's testimony, that's where he was because of the issue with his mother.
Thank you. Anything further?
Not at this point.
Okay. I'm just going to take a moment before I announce my findings.
If I may add, it was the New Haven Yale Police, so he was in the area. He said he was all along.
Who gonna win the Super Bowl?
Okay. Charge 1 of the absconder. I make a finding based on state's exhibits B, E, and G, as well as testimony today. On charge 2, halfway house placement, I make a finding based on state's exhibits B, E, F, and G, as well as testimony. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, on behalf of Mr. McEntyre, my client, 60 years old, as indicated, self-admitted as to why he left on May 25th. He told you where he was. He was still working at the time. He's been working at that KFC actually on and off since 2013. So he's been there for a good stretch of time. As he also put on a record, he still attends NA meetings daily on Dwight Street in New Haven. He's currently medication compliant at the facility. Did suffer from diabetes and asthma, and he's had the same medical provider in New Haven for the past 18 years. He does get reinstated, like to be same area, like to be placed in the New Haven area, which is close to his mother. It's indicated to us he can return back to his full-time job at KFC. As I indicated, he's been there on and off since 2013. He's amenable to any treatment recommendation, and he still wants to continue his NA meetings, which he's been doing even while he was not reporting to probation. Thank you. Parole.
Thank you. I'm going to take a moment before I make my recommendation. Okay, Mr. McEntyre, being that this is your second parole violation and the second time you absconded from parole supervision, and your first one also was you committed a crime while your first time absconding, your whereabouts were unknown for about 6 months. And prior to you absconding, you were supervised for about 2 months before taking off from the, before taking off from the halfway house. But taking all that into consideration, I recommend revoke with no new re-parole date, which is an approximate 7.5 month sanction, being that your end of sentence I have here, so I'm gonna pull it up, is July 11th, 2025. So my recommendation is that you go to your complete end of sentence. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, no contact with co-defendants PK, general no contact with Attler Florian, located at 1166 Chapel Street in New Haven, and Halfley House placement. My findings and recommendation will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on February 6, 2025. So on that day, the board's going to take a look at your case, which again is February 6th. They can lower my recommended sanction, and if they do, you would be informed by mail. Or you can contact your attorney as well. Okay.
Call our office on Friday, February 7th. If you can, Mr. McEntyre, after 11, one of the secretaries can let you know over the telephone if they're keeping you until July or if the board reduces it, okay?
Yeah.
All good? We're all set. Thank you very much.
All right, no problem. Take care.
Good morning, Theo Schaeffer.
Good morning.
We'll get started in about 5 minutes.
Okay, no problem.
P.O. Schaeffer, we're going to get started with Mr. Gura right now.
Okay.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Stephen Gura, 366-876. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office. Counsel?
Yes, Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Gura. I did recently speak to my client. At his request, he is waiving his presence today, and my client wants me to put on the record that he's waiving his revocation hearing today.
And would you like to proceed without your client today present, or would you like for us to have the hearing administratively?
Just administrative hearing is fine by me.
Okay. P.O. Schaeffer, would you like to add anything, or would you like us to receive the report, being that we're going, the client waived, Mr. Gura waived his hearing today?
No, I'm all set. Yeah.
Okay.
Thank you.
Thank you. So this does conclude the revocation hearing regarding Mr. Stephen Gura, 366-876.
Thank you.
Thank you. Thank you.
Thank you. Thank you.
So you should be good to go.
Good morning.
Good morning.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning David Hauser, 430-649. Today is Monday, January 27th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
David Hauser, 430-649.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello.
Good morning.
As well as your parole officer.
Parole Officer DeVylder, Hartford Parole Special Management Unit.
This is a preliminary hearing, which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hauser and P.O. DeVylder, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bring against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violations. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. DeVylder, starting with charge 1, restriction of pornography.
Beginning 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your special condition of parole, you are not to access, view, or possess any pornographic material by any means. Due to the nature of your instant offense, you are prohibited from accessing any pornographic material as it both impedes your rehabilitation and places the community at risk. Charge number 2, enhanced internet and device monitoring. Since your placement at Chrysalis, you purchased, installed, and had been operating a personal Xfinity Wi-Fi wireless gateway and admitted to this on 1/7/2025. You are serving a sentence for a sexual offense where the internet was used in the commission of the crime, which requires you to pay for a software program to monitor all of your devices. At no time were you given permission to obtain this device, nor was this device monitored as required. Charge number 3. Oh, I'm sorry. Part of charge number 2 is still the USB. On 1/7/2025, an unreported, unapproved USB device was found during a search of your residence. At no time are you to have an unreported electronic device. Charge number 3, under problem sexual behavior treatment. A search of your residence conducted on 1/7/2025, you were found to be in possession of an unreported, unapproved Xfinity Wi-Fi wireless gateway and a USB device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from accessing any electronic devices. Beginning 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from possessing any sexually stimulating items and or viewing sexually stimulating material. On 1/1/2025, you were attempting to log into Facebook. You are restricted from the use of social media, and you are purposely and intentionally trying to access the platform. This is a violation of your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior. We also listed the following evidence: A, a remand to custody order; B, PCS conditions; C, the parole violation notice; D, the parole violation report; E, the CTPSB treatment agreement; F, the CTPSB discharge letter; G, the photographs of the unapproved electronic devices to include both the Wi-Fi and USB; H, film description dated 12/29/2024; I, evidence of the search on 12/28/2024; J, IPPC monitoring report excerpts; and K, videos of the cell phone searches.
Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes, I have.
Okay. Today we have no witnesses, and at this time the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. DeVylder?
No, I really don't have anything to say. I believe that the evidence kind of speaks for itself in regard to all of the charges, especially to include the IPPC monitoring excerpts as well as the video of the internet searches. Thank you.
Thank you. Counsel?
Yes, just briefly. Is it DeVylder? Is that how I pronounce it?
Yes.
Okay. Good morning.
Morning.
The charge 1 states that my client intentionally and purposely viewed sexually stimulating material. And then it goes on, it says you are prohibited from accessing. Did you view my client viewing this sexually stimulating material or accessing any pornographic material? Did you actually witness him doing that?
I witnessed him inputting it onto his phone.
You witnessed him, you saw him enter it onto his phone?
No, I did not.
Okay.
This was on his monitoring software.
Did you witness him, you, viewing sexual material?
Through the IPPC monitoring, yes.
So you were watching while he was watching?
No, sir.
So you didn't view him viewing it. You're just assuming he viewed it because it was on a device, correct?
So the monitoring software monitors.
It's just a yes or no question. Did you
I can
see
answer
him?
a question how I choose to answer the question.
Well, then I'll withdraw the question. Yes or no? Did you view him, as you said, you intentionally and purposely viewed sexually stimulating material? How do you know that?
Yes. Yes.
How do
through the
you know
IPPC
that?
monitoring.
It's him.
Because that is his cell phone. He is responsible for it.
But that doesn't mean that you saw him or witnessed him viewing it, correct?
He inputted whatever he was searching for, sir.
How do you know he was the one that inputted it?
Because
How do you know for certain? You're assuming.
So anyone would reasonably assume that a
Okay.
phone that is monitored by IPPC monitoring that is registered to him would mean that that individual himself is viewing.
But you have no proof of that.
I have the IPPC monitoring reports that speak for
But you
itself.
yourself said, listen, I'm not trying to get into an argument. I'm just having you admit that you just admitted that you assumed that he did it. That you said any reasonable person would assume that that's
This
what
is
happened.
semantics, sir.
I'm not here to argue with you. I'm just here to ask you a simple question. As to charge 2, where was it found, the USB device?
In a backpack on the floor.
Okay. Do you know whose backpack that was for certain?
Well, he admitted to possessing the USB device, so it would be his.
Okay. And do you know who put it there?
Him.
You're assuming that.
He told me that.
Okay. And it says that he purchased, installed, and had been operating Xfinity wireless gateway. Is that what you're stating regarding charge 2?
Correct.
Okay. And then in charge 3, problem sexual behavior, you said beginning 12/10 through 1/6, you, meaning my client, intentionally and purposely viewed sexually stimulating material. That's the same allegation there is in the restriction on pornography. That's also an assumption, correct?
Per the signed CTPSB agreement, Mr. Hauser is to register and have any electronic device monitored by this software.
Correct.
This monitoring software is evident that this is what Mr. Hauser is looking at through both the excerpts from the phone and through the internet search when I did take possession of the phone.
That's actually incorrect statement because it doesn't monitor who is viewing it. It monitors that it's being viewed.
So
Correct.
you're alleging that Mr. Hauser allowed someone else to use his phone on a monitoring software and purposely viewed at exactly what he is accused of looking at is mirroring his previous offenses.
No, I'm actually not alleging anything. I'm actually stating as a fact that you can't prove who was looking at that. Correct?
He would have to be giving his phone to other people, and why would that be the case?
Well, it could be the case, correct?
No. It doesn't feasibly make sense.
I don't think it don't make sense.
He is responsible for that phone. Him and only him. He pays $45 a month to have that phone monitored. Do you think he would just allow somebody to go use it?
There's no question posed to you right now. The question is, what proof that you had do you have of your allegations?
The
What proof do
IPPC
you have? I'm not
monitoring
done with my
excerpts.
question. I'm not done with my question. What proof do you have that my client intentionally and purposely, and this is a verb, viewed sexually stimulating material. You have no proof that he did that in charge 1 or charge 3. And more also, you have no proof that it's sexually stimulating material. That's an assumption and a conclusion. And you have also no proof that it's pornographic. There's absolutely no allegation here or proof as to why you're concluding that this is sexually stimulating material. To whom, to where, by what standards, by what definition, and also by what definition are you claiming this is pornographic material?
So first of all, to address your first part of that question, the proof that I have is specifically, again, not to beat a dead horse, is the IPPC monitoring excerpts, the reports from what he's doing, what he's inputting, and as you're questioning as what is pornographic material,
Well, you have to define that.
let's go through the pages, sir. So let's refer to page 6 and 7 where he is researching.
Of what item? What item?
Please stop interrupting me.
What item is she referring to?
6 and 7, you said?
Correct.
Of what?
You refer.
No, the pages are numbered.
Of what? But she didn't say what document.
But the
Parole
pages
Said something of what
violation
document?
evidence.
Of which document?
The parole violation evidence, sir.
Which document?
So it's literally a page number 6.
I don't have page numbers.
No, keep flipping.
Why
Which
don't you look
exhibit?
further
Which
into
exhibit are we
evidence?
talking about? Which exhibit? There are multiple pages of multiple exhibits. All I'm asking is which exhibit are you talking
Page 6
about? Of which exhibit?
of the parole violation evidence, sir.
No, we don't. These are separated into
They're not
exhibits A. Yes, they are. A, B, C, D. You listed them out that way. Which exhibit are you referring to? Boy, this is a hearing here.
Let her give you the, she's going to give you the, you're looking for the exhibit, correct?
I want to just say one thing first, and then we could talk about the exhibit. So when you're looking at his PCS conditions as part of exhibit, I'm sorry, B, under enhanced internet and device monitoring, this explains it all. You understand that you are responsible for all materials and information on any of your electronic devices. So no matter what, that is the phone attributed to Mr. Hauser, and he is responsible for all material and information on that device.
There's no proof he viewed it.
Excuse me?
There's still no proof he viewed it. And there's still no proof.
He is responsible for
But
it.
there's no proof it's pornographic, and there's no proof it's sexually stimulating. You've offered no evidence that it's sexually stimulating, and you've offered absolutely no evidence that what is on the phone is pornographic. Those are conclusory assumptions that you're making. Where is the evidence that those are sexually stimulating, and where is the evidence that it's pornographic? Thank you.
P.O. DeVylder, do you have any remarks regarding those specific questions? P.O. DeVylder, do you need a moment? You're muted. Okay.
I apologize. So where was the last part that you heard me? I apologize.
I didn't hear anything.
Did you hear me? Okay.
So my question to you was, do you have any specific remarks regarding any of the questions Attorney Famiglietti had asked you?
Yeah.
Because if not, okay, go ahead.
I would like to refer to Exhibit I, which is page 6. It's the description of the search that Mr. Hauser had made on 12/28/2024. It is a virtual reality movie regarding stepfather-stepdaughter incest. I can go on to give a description of the video. My beloved daughter shows her underwear, chest, buttocks, etc. to her dad. Daddy, are you getting bigger? Carefully lick your dad's dick and make you squid. In addition, the temptation of the daughter escalate to straddle herself for incest sex. My father and daughter have had vaginal gunshot with forbidden dense sex. I would consider that to be quite pornographic and mature content. To move forward, I'm still speaking. I'm still speaking.
Okay.
We can also refer to page 8, which is pornographic.
By what definition?
By the base, it's erotic content. Page 10. Someone straddling a gentleman. I can't tell if it's a child or not.
It's not part of it.
Page 12, a woman laying in bed moaning. Page 32 and 34.
You have this?
It's black and white, but it's in color. She submitted it in color. You printed off. It's
I
printed
don't know
off.
what she's reading.
She's page.
I was on page 10 right here. Page 10.
Mhm.
There's no writing.
So she was referring to the picture. That's how, for page 10. And then you went on to page 12, correct?
Right, but that's not it.
Correct.
That's
Page 12, page 32. We have both page 39 and 46 indicating oral sex. These are not rated R movies. These are films that are pornographic and sexually stimulating material.
By what definition?
Exactly what I said, sir.
So she can.
Field about anything further?
No.
Okay, thank you.
So my conclusion or my argument is that it doesn't matter what the witness thinks of these things. The witness has a duty and a burden to prove the allegations. And the allegation in charges 1 and charge 3 specifically allege that my client and you intentionally and purposely viewed these. All I'm arguing is regardless of what's in this huge head, there's no proof that he viewed it. Okay, even if they say he had these documents, no one witnessed him viewing them. And that's what they're alleging. You can't allege something based on assumption. And you also can't assume because one person says this is sexually stimulating or that one person makes a conclusion. Those words have meanings. Those words have definitions. Makes a conclusion that they believe it's pornographic does not mean it's pornographic. There's no standard. There's no definition offered. It's just her opinion. And I don't believe that carries. I don't believe that is probable cause or proof to the standard because there is no standard set. It's whatever she thinks it is, whatever the parole officer thinks it is. And I don't believe that is legal. I don't believe that meets any standard of evidence. And I don't believe that meets any legal standard as to those allegations that my client viewed or accessed anything.
Thank you.
And I certainly don't think that these allegations are sufficiently serious enough to go forward with another hearing. My client's been incarcerated since January 7th. There's no proof that he accessed any of this. Merely because it's on a device that he may say is his doesn't prove that he's accessed any of this. Doesn't prove that he input onto the device. We can make assumptions that happened, but we can't assume in the legal world. Thank you.
Thank you. And Field of Elder, I just want to give you one more opportunity to respond.
Yeah, I just want to reiterate that the Board of Pardons and Parole does set that enhanced internet and device monitoring stipulation for specific high-risk sex offenders, which Mr. Hauser does fall under that category. He is responsible for all materials and information on any of that electronic device. I will tell you by the amount of pages in this evidence that obviously there is a significant amount of very questionable material for a registered sex offender to be viewing. Mr. Hauser has only been in the community for a month and a half, and he had gone to inpatient treatment, and it's still apparent that he doesn't see anything wrong with what he's looking at here, which is extremely concerning due to his sexual deviancy. This behavior increases his risk to reoffend. You know, the content of the information that he's viewing based on his previous convictions. And I do want to just ask you real quick, Attorney Famiglietti, would you consider a stepfather incest video
Objection,
to
relevance. My opinion doesn't matter.
Oh, okay, but that's interesting. Thank you. I'm all set.
So, and
Just briefly. It's not my burden of proof. It's my job to hold the state to its burden of proof. Material was just described as questionable material and content. There are levels, there are definitions, there are standards. And merely because he possesses something, I'm not arguing that he didn't, that his phone did not possess it, or the phone did not possess it. The allegations are that he viewed it and accessed it. That's what I'm challenging, because there's no proof of that. There are assumptions.
anything further that wasn't already said, P.O. DeVylder?
No, I'm good. Thank you.
Okay, and anything further?
No.
That wasn't already said. Okay, thank you. I'm just gonna take a moment before I announce my findings. On charge 1, restriction on pornography